right, everybody. Thank you all so much for joining us today for this amazing discussion and series for coordinated community response. Our topic for today is community partnering with law enforcement. So we are joined by three amazing panelists, which David Garvin has set up this amazing conversation. We are live on Facebook, so please feel free to interact with us in the chat. I will be keeping an eye out on that. And if you are joining us on Zoom, please also interact with us. Feel free to introduce yourself in the chat. Let us know who you are and use the Q&A section if you also have any questions that you would like to be answered. This is a meeting-based training or facilitation, and so please keep in mind to keep your video muted if you are not speaking, or use the hand up if you would like to speak, so I can keep an eye out on that. Otherwise, enjoy your training, and please let me know if I can support you in any way.
Thank you, Terry. And everyone, welcome to our second training in the 7-part series on the coordinated community response. Today, we're focusing on partnering with law enforcement officers. And joining us today are Eric Thriekeld, Quentin McShane, and Johnny Trujillo. And together, they have nearly 80 years of experience in law enforcement. And I'm going to ask Pam Wiseman to say a couple of additional words about welcoming our faculty for today's training session.
Okay, thanks, David. I would just like to note that Quentin McShane was a longtime member of our board of directors, and obviously but a state police officer. And now he's also doing work with us on various pieces of legislation and just doing some contract work with the coalition. So thanks, Quentin. Eric Thriekeld is law enforcement from Eddy County and also a pretty long-term member of our board of directors as well. Thanks, Eric. And Johnny Trujillo, who is also law enforcement. This is getting redundant, right? It's a good thing there's only 3 of you. And is from Socorro and also a member of the board of directors of NMCADV. So thank you all for being here.
Thank you, Pam. And we're just going to go ahead and get right in. I want to remind you that on October 27th is our number 3 session, and that's partnering with the district attorneys. So we're looking forward to that. But without any further ado, we're going to hop right in. And I want to start with a personal question for all of our training faculty. And that is, why do you care about domestic violence as a law enforcement officer?
Well, David, for me, it's interesting because I've been to lots of conferences and heard people speak across the country and internationally as well on domestic violence. And most of the people that I've come in contact with have a backstory of either they were a victim of a domestic violence or they had some traumatic incident that occurred that kind of got them started on that road. And that wasn't the case for me. I didn't grow up in a violent home. I really didn't experience domestic violence till I became a police officer. And the training that I received all those years ago was woefully inadequate. And even though I really didn't know what I was doing, I did know enough or realize enough that there had to be a better way. And I just started kind of learning things on my own through trial and error. And eventually I got to go to some training. But what really set me down the path of making this a goal in life to do the best I could in investigating these kind of cases and making a difference in policy and procedure was when I went to work for the Domestic Violence Enhanced Response Team in Colorado Springs. And that really, really opened my eyes. And I got an opportunity to participate in a lot of really highly lethal cases and investigations and travel around the country and look at other various programs. And a lot of people came to visit our program. So that's kind of what got me really interested in this subject matter, and just kind of went from there.
Thank you, Eric. Quentin, you want to go next? You're on mute.
Thank you. For me, where I got it was not all, but a lot of the domestic violence trainers, as Eric said, had a personal experience in their life or with some significant other Uh, I didn't. Had a pretty mundane middle class upbringing, but what got me involved was in January 26, 1991, in Chimao, New Mexico. A friend of mine named Glenn Huber responded to a domestic violence call along for Rio Arriba County deputy. At that time, I was working for the state police, as was he. He was shot in the head and killed. The deputy he was going to assist was shot multiple times and killed. The people they were going to assist were also shot and killed, including a baby. The body count was a total of 7. And my friend Glenn Huber laid on the ground for an extended period of time as we were processing the scene and chasing the person that shot them, which passed. And flash forward a couple of years, there was a training. It was done by a subject matter expert named Grace Barreras. And in this training, they had photographs of my dead friend with his brains outside of his head as part of that training. I was deeply offended, and I said, you can't use that to train. And the question said, could you do better? And at the time, the answer was no. But since that time, I have been doing training and progressively getting better to the point where I like training officers. I like domestic violence cases because, no, I don't like to see people hurt, but I'm extremely competitive. I like to win. And if I see a bully, which I do detest bullies of all shapes and manner, I like to put my thumb on the scale and make it better for anybody that's being bullied and hold the bullies accountable if I could. And there are no bigger bullies than the abusers of domestic violence survivors. That's pretty much how I came into the field. And it's been enjoyable to me. People in this field have been very kind to me for a very long period of time. And I appreciate everything that everyone in the field of domestic violence and sexual assault and stalking has done for me. And I feel I owe a debt to try to repay that at some point.
Thank you. Powerful story. Johnny, you want to go next?
Sure. I started my career in law enforcement in 1977. And this was a time before orders of protection. We didn't have much of a shelter in our town. And we were trained as law enforcement officers in a certain way in how we responded. And domestic violence calls, we were always taught that they were one of the most difficult and dangerous calls. But sure enough, in 1981, I got shot responding to a domestic violence call. And after I had recovered and came back to duty, we started a shelter in 1987 here in our community. We had our first shelter, and I was working from the law enforcement end. And unfortunately, we had a tragedy, a domestic violence situation where the child and the victim were both killed. And knowing that we could have done as a community, come together and protected her and the child, we failed. I always felt we could have done better, and we should have done better. So in working with domestic violence agencies at that point and seeing how we could come together, a lot of roadblocks, a lot of difficulties. In 2001, I retired, and I came to work I became the executive director of a domestic violence agency, which I had been sitting on the board. And I wanted to patch that relationship between domestic violence advocates and police officers, because police officers really didn't have the training or the understanding of what an advocate did. And I saw these walls and barriers that were, that I lived and I experienced, and I wanted to bring them down. I wanted the officers to better understand what the role of a domestic violence advocate was. We're on the same team. We're there to protect and make sure the victim and the children are safe. And in so doing, we needed to work together. And for the past 20 years, we have been working with that in our community, and we've opened those doors. And, community coordinated response has worked for us. There's been other challenges that have come up here recently, and I'm sure we'll talk about those now. But in seeing what didn't work and experiencing that firsthand, and moving to a different platform where seeing what can be done and what is done, that's what's motivated me to continue the work that I'm doing.
Thank you, Johnny, and thank you all for your dedication as our first responders. A lot of people don't know what goes. A lot of you talked about training, and a lot of people don't know what goes into. Let's just start with the academy. How much training does a law enforcement officer generally receive when it comes to domestic violence at the academy in New Mexico?
I'll go. The statutory training is 16 hours, 8 hours of which must be a practical, which is basically scenario-based training. So the academy does 16 hours. That doesn't mean the officer gets 16 hours of training. Not many, but there are times when a department may want 24 hours. They can exceed the minimum requirement in the academy, and there are 9 academies in the state, many of them satellites, the main academy being the New Mexico Law Enforcement Academy in Santa Fe. But state police has an academy, Albuquerque police has an academy, and there's academies that happen sometimes, like the Doñana County Sheriff's Academy, the Southeastern Law Enforcement Academy in Hobbs, and so the one in Farmington, and so on and so on. So it's 16 hours mandatory, 8 of which must be a practical or reality-based. But what happens sometimes is they also have witness assistance, and they will put 2 hours in and they get less than 16 hours. They also sometimes have the victim, all the victim assistance, the witness assistance, the community policing things. Sometimes things that are not truly domestic violence happen in those 16 hours, making that training less. Once they leave the academy, they're required to get 1 hour of domestic training, violence training a year. There's also a 16-hour block that's done in the New Mexico Dispatchers Academy. And after they receive that, there's no requirement at last I checked for dispatchers to ever receive any more domestic violence training.
Fascinating. In your opinion, do you think that's sufficient?
Not even close.
I would also like to mention that 1 hour of continued training, it varies from agency to agency, but many times it does not really focus on some of the new laws that have changed that apply directly to domestic violence. So even though you might get additional training, it might not be relevant to some of the new statutes surrounding, emergency orders of protection, extreme orders of protection. So a lot of officers that say, I've had the training, and you ask them about these different emergency orders, they have no idea what you're talking about.
Okay.
That is even compounded because some of it could be an hour-long video, and there's no assurance that they actually were awake during the critical parts of that.
Okay. What do you think about the and to me, I'm gonna have some other questions about the relationship between district attorney and law enforcement. But what do you think about district attorneys coming in and doing spot training with law enforcement officers?
I think I've seen such discrepancies between agencies pertaining to the training or the interpretation of when they can and when they can't arrest. I know recently, a few years back, Albuquerque had made a statement about, the offender had to be at the scene in order to be arrested. or had to be within a certain distance. But there was some talk if the offender had gone just across the street from the scene, he couldn't be arrested. So district attorneys were trying to give some direction, at least in our area, as to when an officer should arrest. If he gets to a scene and the offender is there and he witnesses the battery, the evidence of a battery, the statute's pretty clear on what he should do. But there was always these discrepancies as to what should be done if the defender's left. If he stopped 20 minutes from the time of the incident, should he be arrested? If he's across town. So it varied, but whatever the district attorney in the area believes or how he interprets that statute as to when an officer should arrest, that should be in stone. That should be clear to everyone in that district attorney's judicial district.
Eric or Quentin, do you want to add anything to that?
So in my experience, district attorneys doing training it can be really effective. I would echo what Johnny said. It's important to know what they're expecting as far as when someone is arrested with the level of probable cause and whether someone's at the scene or not, if a warrant's needed or not. That's really good information to have from the district attorney. And in my experience, it can vary, like Johnny was saying, it can vary widely from district to district, and even within a district. Our district is fairly large, especially geographically. We've got 3 or 4 different cities in it, and it can be very different going from one city to another, how a DA is going to proceed on a case. So it's really good if they can help with in-service training. And I typically, when I do training, I always invite at least the chief prosecutor to come and spend a few minutes talking to our people about what their expectations are.
Okay, that is terrific. And Roxanne on the call is a prosecutor at the 12th, and she was noting that she does yearly training on DV and additional training upon request, which I think is terrific. I think that's a leading best practice, and it's from the sound of it, I think all of you would agree with that as well. That partnership between law enforcement and the district attorney is key to having an actual coordinated community response, right?
One thing that I would add is, particularly in a training situation, you have to have the input of the local prosecutor, because they're charging these cases, they're prosecuting these cases. In many cases, the officer is just a complaining witness, an important witness. But if you're going to cook, you need to buy the groceries, and you need to have it fit your prosecutorial interpretation for it to go forward. So that training should be along the lines of the judicial district that it's in. And what Johnny was talking about earlier is something that's been going on for decades, as to when they leave the scene, how long do you have to arrest and how far away they are. It's a question of how far is too far, how long is too long. And there are 14 judicial districts, and there are 14 answers. And even within the judicial districts, as Eric said, there may be multiple answers in that judicial district. Even in that location, it may depend on who's on call. So we're asking, it's more of an art than a science, but the relationship between prosecutor and officer makes or breaks the system.
So when it comes to what's going to happen in my community, which could be any citizen in New Mexico, if my husband assaults me, the answer is still, it depends.
It depends on where you are. Everybody gets a certain level of due process, and that level depends on where you live. Because in one county, there are timeframes that are kept. In another county, there are not. In one county, they may make arrests Or in another county, they may be on a court settlement agreement, or have, as one county has a finding or an investigation from the Department of Justice, which affects that. It's going to be more art than science, and people have a different level of expectation. In one county, it may be 4 hours before the police show up. In another county, it may be 4 minutes in certain cities. Where you live gives you what rights are available to you.
Any thoughts on what we can do, just as all of us citizens of the state, to be able to ask for some consistency between communities?
And well, yes, and one of the things that we like to share, because law enforcement officers, I don't know of a one that doesn't want to make an arrest. And those that do many times are very frustrated. It's very frustrating to take a person, take them to jail, maybe you have to take them to the hospital first to get checked out, then they get into jail, and they actually walk out before you finish the paperwork. And in New Mexico, in our judicial area, and I think it's pretty much true, if you violate your condition of release, if you get out of jail and when the judge says you're to have no contact with the victim, and you go and do it, and the victim calls in and says, or reports that he has contacted or threatened her again, the officer is limited as whether he can arrest or not, because it's an order, it's a condition of release. It's not an order of protection. So in our area, if we see that, and it's not the prosecutor's fault, it's not the officer's fault that the person gets released. I mean, there's been some legislation that's been passed recently that pretty much mandates that you get the guy out of jail pretty quick. But if you put some thought and you team and make sure there's an order of protection that follows the arrest, and get that in place, even if it's an emergency order done by the officer. I know it's more work for the officer, but you put this together to protect the victim and the children. That way, if he does do it, an officer can go back, because he wants to arrest him. He wants to put him back in jail if he does what he's not supposed to do. But given the officers need the tools, and the community. Now, again, like I said, it's an emergency order of protection, which is separate from the criminal case, that can come together and hold this individual accountable for the violence he's been perpetrating on that victim. So on a Friday, like you said, you call in, and even they make an arrest. Well, you don't know as a victim if you're going to be harassed, if he's going to come back at you, because you're pretty well, unless it's a very serious felony where there's been some serious injury, but if it's a misdemeanor assault or battery against a household member, that individual's going to get out of jail pretty quick. And what's he going to do? He's more than likely going to try to contact or try to intimidate or go back and re-victimize the victim. So law enforcement and the DA knowing this. Now you have an order of protection, right? So you've got criminal charges. He violates the order, the officer arrests, that goes back to the prosecutor. That maybe the next time, that'll be enough to go ahead and the DA can request the detention hearing and keep that person detained.
But that has to be the second time.
It has to, well, it's usually the second time. If it's the first time, and again, understanding what he's done prior to that, his criminal history comes in. But many times in our jurisdiction, we can talk, we have communication with the district attorney, and we recommend and we'll ask, can he be held? And even with the court, now bringing the judges on the team or getting them involved. I know there's some limit as to what they can do and what they can't do with the CCR team, but if you have already talked to the judges and told them, if we have this situation, what are the chances that under this scenario he can stay in jail? And the judge will tell you. The judge will say, well, if it's this bad, and I'll set the bond a little higher, or whatever works. If you have it all laid out ahead of time, you might be able to detain that person with just a couple of phone calls, and everybody on the same page addressing that critical situation.
Thank you. So one of our people on the call, also a former law enforcement officer, Albert, notes that there's a lot of jurisdictional issues that, as all of you have said, it really depends on where you are, what's your zip code, what address are you at when this is happening. What will it take to have that not be the answer? Because one of the things when that happens in a state, what you end up having are some communities are what I would call survivor friendly, and some communities are what I would call offender friendly. And we want to have survivor friendly communities, that promote safety and that hold offenders accountable. What needs to happen in order for that jurisdictional issue to be less significant?
I guess I'm not entirely clear what you mean by jurisdictional issues. I mean, if
of how this area handles a domestic violence case versus one of the areas that what's going to happen, as opposed to it depends.
I think too, a lot of it is the structure of the court system in the area. In Socorro, we have a magistrate district judge set up. In Albuquerque, you have a municipal court. It's not the same protocol. Some areas have grand juries that you've got to, work with. Other places you're having a probable cause hearing. So, and then we're just talking about jurisdictional with state charges, not now when you throw in tribal issues, tribal courts,
Okay.
another complete different system. So, and then of course, some places have military bases. If it's something that happened on the base, then you have, the military justice system, which is quite a bit different as well. And in those areas, becoming familiar with what those systems are asking of you or what the requirements are, that has a lot to do with how a prosecutor and law enforcement are going to approach that investigation. Because if children are involved, are they going to be interviewed? There's going to be a SANE exam, or what's exactly going to happen with the investigation, because now everybody's rushing. If you are detained, the prosecutor has to get everything lined up within 10 days to get it to court. And we very frequently see cases that are dismissed because the prosecution isn't ready. It doesn't mean the DA wasn't ready. It means maybe the evidence or maybe all witnesses haven't been talked to. So there's these other requirements in different areas, just depending on what jurisdiction you're in.
Okay. I want to get to some of the things that are in the chat. And, as I mentioned to you all, I've got a lot of questions, but I also I'm delighted that there's so much participation in the chat, and I'm going to do my best. And if members of my team can help me out in terms of making sure if the things that I'm missing, I appreciate your help. One of the people who put it in there, well, I also want to say, somebody's saying thank you for such a great discussion. So we appreciate that. One of the people mentioned about when she doesn't want to press charges, or she changes her mind about pressing charges. And I want to give you my take on this, because it's always bothered me that we've had that phrase, because prosecutors are the ones who press charges. And it's almost like the system has a way of giving away and I don't think this is happening, but linguistically it's happening, where we have created this phrase, and it's not just New Mexico, it's across the country, and to whatever extent I've seen around the world, we always talk about she doesn't want to press charges. But she doesn't press charges, the prosecutors press charges. But the question had to do, well, let's just start with your thoughts on that notion of where that phrase came from, and the notion that law enforcement has a role, but the prosecutor does the pressing of charges. Eric, I'm going to ask you to hop on there. You might be having some technology problems, but if you can unmute, would like to hear you on that.
Yeah, sorry, I lost we were talking about this before it started, but I actually lost the internet connection, so I'm on my phone now.
Okay.
Yeah, so first of all, that phrase, she doesn't want to press charges, or he doesn't want to press charges, it should never even come up in conversation with law enforcement officers when they're investigating these cases. And I still to this day hear that frequently. I have officers who will ask victims that question: do you want to press charges? And which just completely contradicts any training that I've ever done for them. I tell them, don't ask that. Don't even put that thought in their mind that that's something that they can consider or not, because it's not. Now, if they volunteer that information, sure, I want that in my report. The victim said she didn't want to press charges. That may be an indicator or a clue that how cooperative the victim's going to be on down the road, but I'm sure not going to put that question out to them. And I think it comes from in the years ago, that was the reality in most jurisdictions, that if a victim wasn't willing to press charges, then the case, no arrest was made. Likely a report wasn't even written. But that's not the case today. And even in New Mexico, it's not the case. And it's something that we need to make sure that that officers aren't putting that idea forward when they're conducting their investigations.
Quentin, you want to chime in?
I very seldom disagree with Eric, and he's absolutely right, but I am quite old. And that means if you cut me in half, you'd see like little rings of the history of domestic violence in New Mexico. When I first started, it was before the Family Violence Protection Act. And what people could do is go to the magistrate court and they could file a criminal complaint and file charges on another citizen. And they had that right and that power through the courts. Over time, that power went away, and that power was given to law enforcement to make those charges. And as law enforcement had that ability to charge, many times in the olden days, they would file a criminal complaint on behalf of the person making the charges and sign off. That way they didn't have to pay a fee for making the charge. Flash forward to today, the access to the courts is not the citizens, it is the police in the criminal sense. The citizen has no access to the court except through the police. The police have no access to the district court except through the prosecuting attorneys, the ADAs. So what we're having is our many administrators, the law enforcement, making charging decisions. And when you have a victim, we can't put that on them. As we're looking at our victim and our suspect, and we can't have that question is, lady who just got beat in front of man who just beat you, are you willing to charge this man who beat you? That's not a fair question. It is a responsibility of law enforcement, and the training is you will tell the offender, don't ask her to dismiss charges. She did not make any charges against you. I am arresting you. I will file the complaint and the paperwork. You can come back to me because I am the one that charged you. And also, she cannot dismiss any charges. Can't happen. I will be the one making any dismissals. That needs to be clear, and that is a part of the training. We don't need to put the survivor in the position of being the prosecutor or being the officer. That is not their function. Their function is to survive and live and play to the extent of any happy person. And when we take that away and give them the responsibility of charging, even though they don't have it, if we make it sound like it, if that is the perception, and many people watch TV and they think that is the law, it's up to us to explain it and make it clear. Law enforcement charges, not victims.
I really appreciate your saying that. Also, you brought up how many rings you have if we were to look inside you and count your, and I mentioned already that between the three of you, you have close to 80 years of experience. I don't know if everyone knows, but there's some olden ways of dealing with domestic violence that I think just give us a bit of a perspective. Have any of you ever heard of I think it was called the 3-mile rule or the 5-mile rule? Is that a term you're familiar with?
I am not.
No.
This was a practice where law enforcement, and I don't know the year of it, but it was probably pre-70s. Law enforcement would take the person who had committed the domestic assault to the outside of town, 3 or 5, I don't remember what the exact distance was, and then drop him off and hope that by the time he got back home that he would have been tired enough that he wouldn't harm her anymore. Is that a story that any of you are familiar with? Johnny, I saw you nodding on that one.
Yes, I'm familiar with that story. It was actually a practice many years ago. Talking with one of the old sheriffs, where they would take an individual to calm him down, and they would take him to the outskirts and have him, sometimes just hold him out there, or actually detain him. It was called a 12-hour hold. I'm not gonna arrest you for domestic violence. I'm gonna place you on a 12-hour hold and let things settle down. And they actually did that. And what Quentin was talking about too is that in the 80s and 90s, if you were charged with a misdemeanor, the officer would file the charges and the officer would prosecute. And what you mentioned earlier about whether the victim wanted to press charges or not, well, the officer many times would ask the victim that, because if the victim did not show up for court, the officer would dismiss the case. The judge, there was no witness to the crime, and therefore the officer would dismiss. That's no longer, if it was a felony, and we always talked about this, if there's a murder, the person murdered doesn't ever have the opportunity to say, don't prosecute. You prosecute it. It's a felony. And in many jurisdictions, and it's very encouraging in some areas, they're doing victimless prosecution, evidence-based prosecution, where they are able to prosecute whether or not that victim appears in court. And we have all heard recently about the low conviction rate of domestic violence here in New Mexico. Melissa Binders put out this report, and it shows the different jurisdictions in the state, and the conviction rate is extremely low. But district attorneys many times are faced with the same issue. Even though they are the ones that are prosecuting, it's very hard to prosecute the case if the victim's not there in court. So when they're saying whether the victim wants to prosecute, maybe it's the language today, is the victim going to show up as a witness? Because many times when they don't, the prosecutor doesn't have much of a choice, given the laws the way they are today, but to dismiss the case, nolly prosecute, until maybe they can reevaluate if they want to, maybe there was a reason, or, there was some extenuating circumstances why she didn't show up for court.
But part of what you're talking about really goes back to what's in the police report and the evidence that's collected. Because if a law enforcement officer has as much information in that report, it can create a context that the prosecutor can use,
Yes.
regardless of whether or not the witness is willing or not willing to participate as a witness.
And that's so true. I think earlier, Quentin mentioned about whether or not, or Mary Eric did, about whether the officer takes the report. But recently we had a case where we went to the DA, we wanted to know why. Why wasn't this individual prosecuted? And when we were given the report, now this was a pretty serious case. There wasn't a 7-page report. It wasn't a 7-paragraph or a 7-sentence. The district attorney showed us a police report where the officer had wrote 7 words on a domestic violence arrest. He wasn't ready to go. He had to dismiss the case. There wasn't the evidence. The officers, it's so important that they document as much as they possibly can. And I know it's, your calls are backing up, and, this is the 10th time I've been to this house. But for them and the training that needs to be, given, that they document as much as they can. Now there's a brand new law that law enforcement's dealing with, where they have to have their recorders. And there's an IPA requirement now. Even if they don't take a report, you can request the body cam from that incident and at least use it in the order of protection, or maybe review it and take it to the DA. But it is paramount that the cases be investigated, documented, and it starts there. It starts with a good investigation.
Okay, thank you. I want to pause our conversation just for a minute and ask Gail Starr to unmute. I think you have a comment that you'd like to make, Gail. Gail, can you unmute?
I don't see her in the frame. I think
Okay.
she's away from her screen.
Okay, maybe we'll come back to that. In addition to that, one of the other comments in here, and this goes back to, I think, where this particular thread went. Albert mentioned that officers used to be told no victim, no crime. And that this goes back to one of the questions that we've talked about that I also wanted to make sure we really focused on, was about whether or not he's present at the scene of the crime. And you mentioned it could be across the street, it could be a mile down the road. What is the bottom line on that in terms of his proximity and convenience for being arrested?
I'll take that one. What happened in New Mexico? There was an APD case, and a lot of our case law comes out of APD, which is not surprising. It being in Bernalillo County, one of the most populous counties, half the state living in that metropolitan area, where the suspect left the scene. And the Supreme Court says that, yes, in that case, you could make an arrest, even though he was not physically at where the violence occurred. But again, what it comes down to is how far, how long. How far is too far? How long is too long? There was attempt in the legislature to pass legislation defining that, but that did not go through the legislature. So where we are at is it a determination of, is the victim at risk for future harm and during the length of time and the distance away that suspect is? And obviously, as you go into the next day, you're going to need to get a warrant. But individually, it's going to be jurisdiction wide. Some jurisdictions say you have 8 hours. Another jurisdiction says as long as you're continuously looking for the offender. Another jurisdiction says as long as they're within a geographic area. It's going to be jurisdiction specific and maybe even case by case ADA specific. That it is, what is the risk to the survivor, and there is no codification of a hard metric. It is not a science. It is an art, and it is a soft art.
Okay. What you're saying, Quentin, reminds me of a time when I was sitting in court watching, which I would encourage everybody to do at least once. I think it's a great part of training to watch what happens. But I remember a case, the man ended up coming into my battering intervention program, where the judge said to him, happened to be in a community named Ypsilanti, and the judge kind of leaned over his bench and said in a really stern voice, "You can't beat a woman in Ypsilanti Township." And the man's response was, "Well, then I'm moving." And he was literally that arrogant in the courtroom. And what I later learned, because I talked to him as a consumer, is that he moved to a place which was what we would call offender friendly. Since that happened, in the time, in the years gone past, that community has really changed their tone. But when we have this kind of difference, and it depends on, which one of you said there were 12 or 14 jurisdictions?
Well, there are actually 13, but Gallup
13.
and Farmington, for all intents and purposes, are different. But
Okay.
Roxanne Escabel did put into the chat the case, which is State versus Almazar. That went up to the Court of Appeals, and they said it wasn't at the scene. Then it went to the Supreme Court. They said it was. But in between, the New Mexico Attorney General's office issued an opinion that it is determined on the safety of the survivor, and it's a reasonableness standard. Everything seems to be a reasonable standard. That is the state of play.
Okay. Okay.
And one of the other things, you have this guidance that's set, and I know recently in one of our CCR meetings, 3 agencies had 3 different answers for the same scenario, whether they would arrest or not. So even though you're in the same jurisdiction, depending on that agency, and I'm pretty sure even within the agency, it's going to differ from officer to officer. But what's great about being able to have open communication with law enforcement is understanding maybe the sheriff department isn't going to make an arrest because he's gone down the street, but the state police will, or the city police. But asking them the question, putting it on the table and getting some discussion on it really actually enhances the training, because it starts, if one agency is doing it, why can't I do it? And there's some discussion, and many times a lot of agencies don't talk to each other. They don't talk to each other, they maybe wave, but understanding what they can do to come together to make it equal in an area. It would be great if it was statewide. If the same, you'd get arrested, for and held accountable for your actions the same way in every jurisdiction. That is something I don't know if I'll ever see in my lifetime, but it's something we can always try to work with and try to focus on.
That sounds like a great goal. So going back to the issue of working with survivors, there's one of the questions has to do with confidentiality when a survivor's been accepted into a safe house, a shelter. What are some of the issues from law enforcement's perspective about what can be done to deal with the limitations that organization either is under or may feel they're under? Even if you just dropped off a survivor 30 minutes beforehand, but you need to come back to collect some additional information, or maybe do what we've learned over the last 30 years of, we want to take pictures at the scene of her injuries, but we want to come back a couple days later because some deep tissue bruising doesn't manifest, and we want to take pictures of those a couple of days later. And you're met with, we can't confirm or deny that we know who you're talking about.
So I don't really see that as a limitation. It's just a matter of building trust and relationships with the people in your shelters. And it's not a difficult hurdle to overcome if you just make a phone call and word it as, hey, I know you can't confirm or deny. You can start out with that from a law enforcement perspective. But however, if you're to come across this person, if you could let them know, I'd like to take some additional follow-up photographs, or I need the secondary interview, or whatever the situation is, and they're going to make that happen. I mean, their purpose is to protect women and victims and children and make them as safe as possible. And if you're being reasonable in your approach, they're going to be reasonable back. I have never dealt with an issue, and the same comes for, and if it goes beyond that, and and you have to get into the shelter for some reason, then you make that case to a judge and you get a warrant and you follow the procedures. But personally, I've never had to go that far because we have good relationships with the people that run those facilities.
And I think that's, you just said it, Eric, you hit the nail on the head. All of what we're talking about, it's about relationships and how do we play in the sandbox together when it comes to working together to promote survivor safety and offender accountability. And, you know, knowing someone where you can call and say, hey, I need to come over and do some follow-up evidence gathering, photography, additional questions for the victim. It comes down to our relationships within the community.
But there are differences. We have different agendas. Whereas in advocacy and prevention and service providers, we serve the survivor. Batterers treatment, we serve the treatment of the offender. Law enforcement serves the community. And if that community is a jealous husband who uses law enforcement to say that his children are being abused and they're being held in a shelter, and we want those children out and that woman prosecuted, law enforcement's agenda is not only for the survivor, it also serves the complainer, it also serves those children. And the way around that is we need to have those discussions between law enforcement and shelter providers upfront before there's an issue, before there's a child, before there is the possibility of conflict, because it will happen. It has happened. It will continue to happen, that there will be someone within a shelter that law enforcement wants to talk to, arrest, interview, or remove. We know this will happen, and those personalities and relationships must be set up ahead of time. And it's not that anybody's a bad guy. VAWA and licensure on behalf of our shelter providers restrict them from giving that information, and there are laws that say that. But law enforcement has sworn an oath, and they will uphold it. It's happened, and there's probably not a shelter, if they have a long memory, that hasn't dealt with this. And when pride gets involved, in some jurisdictions, our district attorneys have been involved where they feel their purview has been involved, and warrants have been issued. And if you do a search warrant in a shelter for something the size of a person, every client in that shelter, every room in that shelter, and if you're being persnickety, that's not a word. If you're being nitpicky and you ask for documents, you've destroyed confidentiality across a great deal of people. Of course, the shelter will move the quash. The shelter will get their attorneys involved. But when law enforcement's knocking on the door, there's no good ending to that.
Mm-hmm. Collaboration and relationships. You break down collaboration, co-labor, right? Working together. There's a comment in the chat about SANE nurses doing exams and taking pictures. And clearly when it comes to sexual assault, I think the general public has pretty good knowledge of that. Have any of you had any experience of working with sexual assault nurse examiners when it comes to domestic violence cases that weren't sexual assaults? Eric, you want to go?
So we're really fortunate in Eddy County. We have a SANE nurse who also does domestic violence exams, has specialized training in that. And I would say that that's not always the case all across the state. So if you have someone who is able to do that, they're a wonderful resource. She does strangulation exams and has a really fancy camera that they got a grant for that can really highlight injuries that are hard to see with the naked eye, but this camera will bring them forth. So it's a wonderful resource. And Perry it's a good point. That might be your end to having someone in a shelter have the follow-up photographs taken. especially if you're saying nurses affiliated with the shelter, and in our town, they're not directly connected, but that's surely someone you want to establish a good relationship with. And we encourage our officers that if there's strangulation involved, for sure, we're going to do our best to get them in to see the same nurse and get that DV exam done. But even if not, we train our officers that this is a resource. It doesn't have to come to the detective division. It's something a patrol officer can do to set up that exam and get those much better photographs than most patrol officers are going to be able to take with the camera equipment that they're issued.
Wonderful. And I want to draw everybody's attention again to the chat. Mary Ellen Garcia notes that there are 4 programs that are authorized statewide to conduct IPV and SANE exams. And that's great. And I'm just curious if anyone on this call can speak to whether or not in your coordinated community response, whether they're meetings or just affiliations, if you are involving the SANE nurses in that process. We'll see if anybody is able to say anything about that.
I can for Sandoval.
Okay.
Standing invitation. Bernalillo County, Gail, who's back on the chat, regular attendee. Other counties, I can't speak to, but those 2 I know.
Okay. Johnny, it looks like you're talking, but you're on mute.
I know here in Socorro County, we have teamed with Valencia County and also established protocol for subpoenaing the same nurses for information, especially when it comes to children. And I know Stacy with the district attorney's office here. She's one of the main prosecutors. She's set some protocol for law enforcement even on how you're to approach and conduct the initial investigations and what the DA is asking. And because of our MTD meeting and our CCRs, there's now, a better way or a strong understanding of what the DA needs to prosecute these cases. So it's been a very positive. It's been fast moving in our area, but it's working out, and it's we assist with whatever we can, even if it's transportation to the interview or support, but it's playing a huge role in the success we're having in the cases where those SANE investigations have been done.
Thank you. And Gail Starr, wanted to invite you. You had a comment earlier that you wanted to make, and here you are.
Hi, sorry, speaking of working with law enforcement, they had to come and pick up some charts on cases that we had done with them. I just came in on the tail. I did make a comment. Albuquerque SANE is involved with several MDTs, the surrounding counties. I have to say the Zoom meetings make it a lot easier to do that. And we are planning on opening a satellite office in Los Lunas, which will assist with Socorro County as well, because we have started going to that MDT as well. We were distressed to see a prosecutor talk about having the victim sign the affidavits of non-prosecution. And we did address that during an MDT meeting. And I think that MDT meetings are absolutely invaluable so that people can understand where each other is coming from. But the science is absolutely against doing those affidavits, that victims need to have those cases taken forward by the state, regardless of whether they're able to be cooperative witnesses or not. And I know that going forward with the non-victim cooperation, so that they're not even they're either a hostile witness or they're not called, has been successful in some areas.
Thank you.
That's kind of what we say.
Thank you, Gail. Appreciate that. One of the questions that came up earlier also was the notion, and I might not have the term right, but witness tampering. So if the person who's being charged does something to intimidate the witness or convince her not to come, Are you seeing cases like that being prosecuted in New Mexico?
This is, I worked on one after I left law enforcement uh, out of it was Silver City. And what it was the technical term is forfeiture by wrongdoing,
Mhm.
which is that because of the acts of the offender, the victim couldn't testify. In this case, he killed the victim. So that murder, all her out of state statements came in because of his acts and the forfeiture by wrongdoing. That testimony was an exception to hearsay and was in part of this guy getting convicted and put in the penitentiary because of him killing her. He made her unavailable for trial.
Yeah, the concept of forfeiture by wrongdoing is not a new one, but I find that very few people actually know anything about it, including prosecutors. So we talk about that in our training here with officers about how important it is to collect that evidence that someone's intimidating a witness or making statements on jail calls, trying to get third parties to get victims to drop cases. There's a plethora of ways that people do that, but it can be really effective if you have a prosecutor and an officer working together on gathering that information.
I know that's true. You talked about evidence, Eric. What are some things that should be in a police report beyond the general things that you would normally see there? Well, like, what are some cutting edge ideas about the evidence and information that should be in a police report that often doesn't get there?
Well, I don't know that they're cutting edge ideas, but there are a lot of things that I see in my experience, that a lot of things that aren't gathered. That's to me seems like common sense, but it may not be it's definitely not if you haven't had some training. But things that you can look for is 911 calls, for example, actually getting those recordings and entering them into evidence, and not just entering them, but actually listening to the recording, because it's amazing the detail that you will hear on that phone call that a dispatcher probably heard or a call taker may have heard, but they didn't share that with the investigating officer. So it's really important to review those. And actually, that's part of our policy. It's mandatory that you collect those recordings and listing them in your report so that the prosecutor knows that it exists. And, gathering text messages, cell phone records, taking those follow-up photographs. We typically, we don't, in my experience, officers don't spend nearly enough time doing initial investigations. They want to get in and get out as quickly as possible. And I kind of use the analogy of how much time do you spend investigating a traffic crash that doesn't have injuries, and sometimes we spend hours doing that, blocking the road and taking measurements and photographs and interviewing witnesses. And we have to do even more than that on domestic violence cases, looking at them as our next homicide case, because very often that's what they turn into. So we want to make sure that we're talking to the neighbors. We're doing a neighborhood canvas, that we're interviewing the children if appropriate, that we're looking at, is there a history of domestic violence with this family? Checking what we call the triple I for previous convictions of domestic violence, asking questions about injuries that you can't see, not focusing in on what's the obvious right in front of you, but what can I not see? And there's just a lot of steps that we have to take, and interviewing.
Oh, we had Eric freeze up. Johnny or Quentin, you want to finish Eric's thought?
Well, Eric he was on a roll, and I agree with everything that he said. And social media has become a part of it. Cell phones are a part of it. The ability to pull lifestyles and information off of a cell phone is a part of it. post threats, bullying on social media is a part of it.
Mhm.
It's moved into a lot of our threats are digital. And I'm waiting for Eric to pop back up, but but in case he doesn't, everything that he said, and I'll defer to Johnny.
And, one of the things that we've been able to assist with in working with law enforcement, because Eric was right on point. When you have to present the evidence of a video that the victim has of what happened, or text messages, it's not where the victim is going to hand the phone to the prosecutor. The prosecutor is going to need those transmissions, those clips of the social media. So many times, our victims are harassed. There's so much. There's also, incriminating evidence that the offender will leave on a voice message, and exactly how you capture that and preserve it and give it to law enforcement so the chain of evidence is not broken and they can use that. It starts to stack up. We had one case where there were over 100 transmissions from the offender to the victim, but we were able to, what she had just on her phone, to separate the video, the texts, the voice messages, it's technology now, and officers, the initial officer coming in, doing the investigation, sometimes is overwhelmed. I mean, that's a lot to ask to try to capture and put together for the prosecution. So working together, coming together and being able to, get what's needed to hold the offender accountable and have a successful prosecution starts from the very first minute that officer gets to the scene.
And also, we must count that not everything on our phones is good. We have to have those discussions up front that we will give you specifically what is pertaining to your case. Even if you have to see everything, we do not want our life turned over to the court. And once we turn over something to law enforcement, it becomes a public record. There are discussions that need to be held on the extraction of data from any electronic device, be it a computer, cell phone, tablet, or otherwise.
Good point. Good point. One more question on the issue of evidence, and then I want to get to some more questions about text messages. Are in New Mexico, are jailhouse calls recorded?
Most agencies, most detention centers, yes. And a lot of them use the paid system where will you accept a collect call from the Otero County Detention Center. I'm not aware of any that aren't recorded at the penitentiary level. At the jail level, it's more likely than not.
Okay.
Ours are all recorded.
Is that evidence that you've seen being used when it's come to forfeiture and wrongdoing cases, where he's calling her, typically the he and her?
Yes.
Let me be clear. Although I was involved in one case, forfeiture by wrongdoing is a unicorn. You're not going to see that in the wild. It happens, but not often.
In terms of being charged, you're saying?
No, in terms of existing as a concept that's brought to the court.
Okay. In terms of survivors' experience, it's happening.
Oh, obviously, yeah, people are threatening, but when I say forfeiture by wrongdoing, I'm talking about a prosecutor charging an individual using out-of-court statements against the offender's interests that were made, and then he did something to keep it from happening. What you're talking about is witness tampering, which is, yeah, that's almost par for the case.
Okay. And there's it's a fascinating conversation that we're having, where I'm listening to all of you and your nearly 80 years of collective wisdom, and I'm trying to watch the chat, which is really lively. And there's a question about text messages being considered in as hearsay in many cases, and then Roxanne noted that not necessarily. Can each of you talk from your experience about whether or not you've seen text messages actually be admissible?
I'll go first. Depends on the court or the hearing. If you're in an order protection hearing where the standard is less, it's more. Many places you take a picture of the text, they'll accept that. Other places they want the phone and you show the phone with a text that hasn't been deleted. If you get technical and you want an actual extraction from the phone, which is some jurisdiction, it's hit and miss all over the place. There are different standards that a court will take, and you have to know your jurisdiction, your district attorney, and your courts. In magistrate world, where we most live, a photograph is usually acceptable. But in the metropolitan court or the district courts, it's a little different.
Yeah, that's been my experience as well. It varies from judge to judge, courtroom to courtroom. But you know, when you talk about jail calls in our jurisdiction, it's an amazing system. I mean, I can go in and if set the system up so if someone who's incarcerated is calling a victim, every time they dial that number, it's also going to ring my phone, and I can listen into the conversation without him even knowing that I'm listening. And so we use that extensively on homicide cases and domestic violence cases, and it's really great. Like Quentin was saying, with protective orders. So when a victim goes to get that order made permanent, and you can go in and speak to the court and say, look, right after he was arrested, he was immediately on the phone calling the victim, making threats, trying to get her to write letters to the district attorney to drop the case and so on. I mean, those are just examples I've dealt with. So yeah, it's a really wonderful system.
Okay. Quentin, as you were talking about and said again, I should have a meter for how many times you all have said it depends. I flashed on that line from the Forrest Gump, you know, life's like a box of chocolates. And it seems like domestic violence response in New Mexico is kind of like a box of chocolates. You just don't know what you're going to get.
Well, you do know what you're going to get if you know where you are and who you're talking to. In a large extent, it's personality based. Like you said, in one county where you were from, the rules were different than the county next door.
Mm-hmm.
You know where you live. You know who you're talking to. You've seen this judge before. You've met that prosecutor. You know the culture of your police department. They're not surprises. There are no surprises. You know what you get where you live. It may not be what you get next door, but you know what you get.
Interesting. Really interesting. Thank you. So one of the questions that came through in the chat also I want to get to is, what do you do and what are best practices to determine or ascertain what at one point was called the primary aggressor, and now the language is more around predominant aggressor? Can you talk about that?
I can address the issue of where it rolled back to dual arrest, where officers were arresting both parties, and then through training they were going to the primary aggressor. Now there's some great training out. I was introduced to it through CYFD. Albert and David with CYFD gave us the opportunity with Safe and Together for a perpetrator-based approach to investigations and holding accountable the perpetrator and moving away from the failure to protect. So we've done a lot of work with that, but you know, it wasn't too long ago where there were dual arrests and there were by law enforcement, and through training and education, you know, looking at, you know, when they start saying who the primary aggressor was, well, that even has to be broken down as to, you know, what the historical domestic violence is within that family dynamic. You know, is she reacting to something that's been going on as a pattern for a long time? So all those things, the more education, and when you bring the CCR team together, that's what's great in our area. We can bring that historical information and we can relate that to the officer or the prosecutor as to what the dynamics have been. and why you are even thinking about charging the victim with a crime. You know, why is there even why is there even a threat of taking her kids away? So moving from that platform, and again, through a coordinated effort, we've seen some results, especially with law enforcement.
So one of the questions in the chat was about judges attending your CCR meetings. And Johnny, since you're talking, but I'm interested in all of your experience. And I for judges, clearly, if there's an active case that's being talked about, I'm sure they would excuse themselves from the meeting. But in your community, do judges attend the CCR?
We've had, and we're fortunate because our last two magistrates have been former police officers. So they've also they wore that hat and they were familiar with what we were going to be asking them. And one of the things that we brought them to the table and asked them about is giving hypothetical situations, a scenario where how can we keep this individual in jail? Why is somebody getting a no bond or a low bond and other people is getting a 1,500 or a cash surety? But understanding where the judge is coming from and what information he actually sees on the criminal complaint. And, politics are going to play a role. I don't care what anybody says in every jurisdiction, who that person is in the community, whether his attorney's calling, what relationship he has to law enforcement or to the court. That's just the animal we deal with. But we've had some success with bringing judges to the table only on hypothetical situations and not specific cases. When we start talking about specific cases later on in the CCR, they leave.
Okay, great. Quentin or Eric, do you want to say anything about judges attending in your experience?
In my experience in the CCRs that I attend, the judges do attend. And there is a school of thought, and I've heard in prior other CCRs that I've been associated with, it interferes with their neutrality, and they don't want to be in a domestic violence CCR because they want to be able to be neutral as they want to look at both sides of the offender, if there is an offender in a case, and the survivor, and making those the determination who is an offender, who is a survivor, is there probable cause to detain or convict. They feel that being a member of a CCR prejudges them from doing that. But all the CCRs that I presently attend do have judges.
Mm-hmm. Eric, what's your experience?
So we no longer have a CCR in Eddy County. We did about 5 years ago. I actually was one of the persons that's instrumental in forming it. So I can reflect back on that, and there were judges who would come on occasion, but not regularly. And we never really got to the point we were discussing specific cases within our CCR anyway. But it was a lot of work getting those people to come to the table on a regular basis. They're very busy trying to fit that into their schedule. Now with the COVID situation, things like this would probably work really well. Doing Zoom meetings might get better participation. But we were meeting in person, and it was hit or miss whether judges would attend, especially district judges. It was really tough.
And I would just add, in my experience of being involved in CCRs to varying degrees over the last 35 years, judges have always participated in those meetings, even, when they were really small and we talked about, law enforcement came to the meeting and they said, we had this many arrests this month. And the probation said, I did this many PSIs this month. And the judges said, this is how many cases I heard this month, and gave outcome information, to when it got really big and kind of highly noted, judges were always at the table. So the question in all three of your experience about in your experience with CCRs, Are individual cases being discussed?
For me, yes. In every CCR or MDT I'm in, yes.
For us as well.
As I was saying, for ours, we were not at discussing specific cases.
And again, I would add that if there was some case that had some element that was still in process, the judge typically would excuse themselves from the meeting or would invite the prosecutor and the defense to that meeting if there was some need for that, where both sides of the party were present to talk about that. Well, I want to keep going here, and we talked about, and Eric, I think you mentioned about, these cases often will end in homicide, and that I know that in a report that just came out last month from the Violence Policy Center, New Mexico is now rated as second in the nation for domestic homicides. Essentially the homicide rate of 2.64 per 100,000, looking at the 2019 data. What do you think about the adage that good law enforcement response is homicide prevention?
Well, again, in my experience, that's exactly what it is. If we're doing our job as we should be. And you were talking earlier about the lack of consistency across the state, but I think one thing that really should be addressed at the legislative level is mandating that reports are taken on domestic violence calls, because it's not always the case in across the state. There's no uniform reporting. There's no uniform reporting form for law enforcement to use. Some agencies use a basic state form that's the same thing you would use on a burglary or a larceny call. They're not specific to domestic violence, and that can be really helpful. That's something that could be addressed by the legislature is look, yeah, if you respond to a domestic violence call, you're going to have to document certain things, and there's a specialized form that you're going to use to do that. That would generate some consistency. And I know from being on the intimate partner violence death review team for several years, and I don't know the exact statistics, but it's very, very high, where you have intimate partner deaths, domestic violence related deaths, where there were previous calls for service at that residence that were never documented by police. And I'm not saying that if they had made a report that would have necessarily prevented the murder that was to come, but however, we would probably never know, because you don't know what systems could have been kicked into place, what the wheels that could have been started to be moving if officers had taken that report, done that lethality assessment. That's another thing that I think should be implicated or indicated statewide, as a lethality assessment form of some kind. So it shows officers clearly when they're investigating, hey, there's a high risk of lethality with this family. You can explain that to victims, and it hopefully could add to the homicide prevention that we're trying to achieve.
Excellent.
Well, the coalition, we're looking at a legislation that would bring back a domestic violence report. The last time I think that was tried, and I may be wrong, was Mary Jane Garcia in 2010. She had a bill for a uniform domestic violence report that would replace the report that people are using. And that report, the sample attached to it, had a risk assessment as a part of it. That idea has been around, and what you would gain from that was, besides uniformity across the state, you would also have the ability to draw down data. Right now, if you want to know if a gun was used in a domestic violence, you're going to be looking in any number of places on any number of forms and reports and processes. If we had a uniform report, we would actually have a grasp on what is happening if that form report was widely used. Now we do not. We do have the work of Dr. Campanera, who does a report annually, but not everybody submits to that. We do have the federal government on the UCR reporting. Again, not every agency submits to that. If we had a mandated form for law enforcement, we would be able to tell you how many times was there strangulation. We would be able to tell you how many times were there child witnesses. We would be able to tell you what body parts were often struck. That information now is anecdotal and it's hard to stand behind. But a uniform report would bring us a lot of things.
Speaking of that, when you're on a call going to a domestic, and I know I'm going to ask you some questions later just about cases that they don't come in as a call for domestic, but they end up, you determine that they're domestic. But when you're on a call, how much do you know about what you're walking into?
Sometimes it's Groundhog Day. You've been there, and then you went back. You've been there for the grandfather, you've been there for the father, and now you're there for the son. But every time is different. You don't know if the person had a bad day. You don't know if they had a experience that made them like you or hate you. And you multiply that by how many people in the room, because humans are unpredictable. We don't know. But we do know certain information. We do know we're probably not the most popular person going in the room. We do know we're carrying a gun in there. There's certain things that we do know. There will be a gun, yours, and there will be some level of communication and conflict. But it's, like I said, a soft art. And that's what I like about it.
Mm-hmm. Eric or Johnny, do you want to add to that?
So there's a lot of things that we know that we could know if we just asked the right questions, officer. And that, what I mean by that is, before you even get on scene, we talk about the lack of consistency across the state, but generally within our own jurisdictions, we have some consistency about the kind of data that we collect, which, for example, we can ask our dispatchers, have we had previous calls for service there? Mm-hmm. What is the victim telling you? Are there weapons present? Are there children present? Is the suspect still on scene? Are there any injuries? And part of that is training your communications people to ask the right questions. Something that we do here. For example, if they know if a victim says, "Hey, I've been strangled or choked," or whatever term they use, that the dispatch is going to stage a EMS nearby so that they can come to the scene as soon as possible. But training officers to, if they're not getting that information from dispatch, to ask them, "Hey, had this come in on 911? Is the suspect still there?" Those are all things that we if we don't know, we can find out before we get on scene.
But it sounds like you have to know to ask for them.
There's one thing. There's one thing. Even as you're driving to the scene, you'll look in the yard, and the cars, they're going to tell you you're receiving a great deal of information, more information than you probably need. Tricycles, swing sets, children, dog houses, dogs, houses will pass between them, a compound, an extended family, lights on, lights off, sounds. Your entire sensory perceptions are there. You're receiving awesome amount of information just walking up there.
But that's if you have an eye to see and an ear to hear, and which goes back to the training, right?
Or so, if you know to look at a bumper sticker. If it says insured by Smith & Wesson, property or local banditos, that tells you more than who they voted for in the last election. If you look in the right places, the information available is awesome.
Okay. So you mentioned about 911. I don't know how much people know about the relationship between law enforcement and 911 centers. And there's a lot of, I think, Quentin, you said there was, what, 40 in the state?
What?
How many 911 centers are in the state?
Approximately 40, yeah.
40, okay.
Approximately that.
So how often do you have conversations other than on a call with 911? Like, are 911 operators part of your CCR? Do you have meetings apart from the CCR with 911?
They're always invited, always. Uh, we've had them present their perspectives and needs in CCRs. But if you have a CCR, you need 911 in there because they'll be able to tell you, we do not dispatch this call to officers on domestic violence unless that person is on scene, which was the case in one jurisdiction. We will call it a priority 2. We'll get there in 3 to 4 hours. Or if this happens, we'll call it a priority 1. We'll actually send someone right away. You need them in the room as they deal with the entry of orders of protections into NCIC, as they're often the ones that hold orders of protection that can verify them. They are a big player and always should be considered and invited.
Excellent.
Yeah, they definitely need to be at the table, and they also offering them training on domestic violence is really helpful. That in many jurisdictions, including mine, dispatch or 911 is a separate entity from the agency that I work for, and they don't directly answer to us. But we can sure build those relationships and say, hey, these are our expectations of the information we would like to see you gathering for our officers before they arrive on scene, and questions that we would like you to ask of the caller or the victim. And they have their own training, but it needs to mesh. Other agencies, the 911 call takers and the dispatchers, work for the agency directly, and that may have a lot more impact with that.
Okay. There's a question from Emily. I'm not sure. We have 2 Emilys on the call. Would the Emily who has a question go ahead and unmute? I've asked you both to unmute because I'm not sure which Emily has a question.
Emily Ellison.
Okay, Emily Ellison, can you go ahead and unmute? Okay, we'll have to come back to Emily Ellison. So here's a question. This could be fun. What are some good ideas for community collaborators, whether they're the battery and intervention programs, they're the survivor service organization, any other community partners? What are some good ideas for partnering with law enforcement? You know, not everybody can pick up the phone, feels comfortable picking up the phone, calling your police department saying, hey, I'd like to come by and bring you cookies and just have a meeting with you and your staff.
Feed them is correct answer. You must feed them. If you feed them good food, they will show up. The 12th Judicial District, they have a law enforcement luncheon periodically. Food and drink is always good, and not alcoholic drink, but sometimes it greases the pathway. Buy them a pizza, say there will be free food. They are cheap. I don't call them names, people. They will show up.
Yeah, I agree. Food definitely will get people to the table.
Johnny, anything you want to add other than pizza, tacos, and cookies?
That's always been a successful recipe in our area to either have it at we used to have our CCRs at a K-Bob's, and then we moved them some other place for confidentiality issues, and we saw the number go down. But bringing, having someone cater it is always good. There's always a cost, but the other thing is just being able to share information. The dispatcher, I hadn't thought about bringing dispatch to the table, but now we're going to because when you start offering the different resources that you might have, I know when we started sharing our ODARAs, with law enforcement. And we were amongst the service provider when you said a person was an 11 on an ODARA, and that's the danger assessment that we're using now. That was primarily set up for law enforcement. But when you start talking in those terms and sharing that information, and we've had law enforcement now take the ODARA training. We've had other service providers take the ODARA training, and being able to offer that, and of course, what Quentin and Eric mentioned earlier about other data. So many times what's lacking and what law enforcement needs to know are mental health situations where you're dealing with an offender who has mental health issues. That elevates, one of the officers that's been there 3 or 4 times might know that, but a new officer that's going to the residence for the first time doesn't know that. The other thing is, we all know that during the time an order of protection is issued and served, the crisis, the potential for lethality rises with the offender, and officers needing to be aware that an order of protection is in process or has just recently been served, and now they're going to the call. It might be a lot different than what it was 2 weeks ago, because now he's in a different state of mind. And I think with that, getting everybody to the table and discussing these things, 5 years ago in our area, when you mentioned danger assessments or DARAs, no one even knew what you were talking about. But now when you talk about somebody and you say, well, he's an 8, and you have on the ODARA, and you have a prosecutor say, well, if he gets charged, we're going to detain him. But again, too, having the ability and the resource for the DA to offer that information with backup to the judge means all the difference in the world, whether the person's going to be detained or not.
Okay.
So that's just another, another benefit of having these CCRs with as many people attending as possible.
Excellent. And Emily, you can go ahead and unmute now. Emily, looks like we lost Emily again. So, the idea of continuous quality improvement when it comes to law enforcement, we talked about training. What else needs to happen in order for your world to do better? All of us have things to do in our worlds to do a better job. Battering intervention programs, we're constantly considering what we should be doing around curriculum. Survivor services are looking at how we can improve. What's on your list of things for law enforcement to do to improve?
I think you need a baseline, because as people get good at it, they promote. As people get good at it, they transfer to something else. As people get good at it, they leave the profession. And what happens is another academy class comes out and you start over. Do you ever get past 101? Maybe you don't. You're just recycling information with different people. As you deal with specialized individuals or your champions, the people who do it really well, then you can get into the higher level discussions, the higher level training. But if you can get your basic patrolman to do your basic, slightly above average job, I think you've done quite well. If that can happen across the jurisdiction between agencies, that a victim can call and get a medium to high level of service from the responding officer, that's the level of training you need to get. And we're not there. And it's really hard to see when we're going to reach that level of mediocrity. But until we do, it's just going to be a hard road to go. If we hit that, then we can try to train them to be exceptional, give them the exceptional training where they're looking at maybe the 301s and the 401s and the graduate level work that you want them all to do. But if you can just get them to show up, write a report, and have it be competent, I think if we can get to that level of professionalism across a jurisdiction, I think that's where we should strive to be. Once we get there, if we ever do, we can look for being good.
Good, better, best, right? Eric, do you have anything you want to add to? Eric, do you want to add anything?
Well, I think Quentin hit it on the head there. I mean, that we're very far from that ideal in many respects. I mean, you just look at the minimum training required in a police academy of 16 hours. It's ridiculous. You can't effectively train anybody. We spend way more than that teaching lots of other subjects, firearms and defensive tactics and accident investigation. And so it's just it's taking these cases seriously, treating them like as if they were felonies, even when they're not, and getting that basic investigation, collecting the evidence that's there, and building those relationships in your community so you can move these cases forward.
Okay. I'm about to go to Emily, but before I do that, and Emily, as I'm talking, you can go ahead and unmute. I do want to point out that of all of the professions that we think of when it comes to responding to domestic violence cases, there's only one profession that requires training in domestic violence. It's not required for a social work degree. It's not required for a medical degree, whether that's being an MD or an RN or anything else. It's not required for attorneys. It's not required for anybody except law enforcement. So at the same time that we're saying law enforcement needs more, I want to say we all need more, right? I mean, New Mexico's just doing an incredible job of providing ongoing trainings, like this one, like everything that's going on during the month of October. But all of our professions need more. If you have a class in domestic violence in social work school, it's only an elective. So it's law enforcement is doing great.
I tend to disagree with you. We're great at preaching to the choir. We teach those who want to learn, who are those who need it least. It's like if we had a judicial enclave, the people we want to go to that part of the enclave, they're not there. As we teach law enforcement, the people that do the worst jobs, they're on the range. They're in a reconstruction class. They're not getting the good training that's available to them. We preach to those who want it, and those who want it are the minority. My opinion only.
I agree with you, and I appreciate the correction.
I would agree with you definitely that there are many other professions that could benefit greatly from training on domestic violence. We've case in point here in Eddy County, Angela Parent, who's a SANE nurse here, and I have trained several hundred firefighters, nurses, EMTs, and it's been really, and of course they don't get that training. Nurses don't get it in nursing school, doctors don't get it, and even when you're just talking about strangulation, for example, and that's mostly the training that we focused on, they don't get that. And so there's a lot of education that needs to go on, because the police are just one cog in the wheel, and there's so many other ways that so many other professionals that could catch this in the early stages and help move it forward.
True, right. I mean, as a social worker, I'm required to have a course in research. I have not done any research, but I've done a lot of work in the world of domestic violence, and I never had any training in that. So we are ready now to get our question from Emily Ellison. Emily, go ahead.
Hi, okay, so my question is, if one of our agency employees gets a notice of a hearing, not a subpoena, but a notice of hearing, is there anything we need to do, or will the agency employee be expected to do anything at a court hearing? And so this is coming from a state court, but because we're also right near tribal lands, we interact with tribal courts with the Navajo and the Zuni Pueblo, and we're chartered with the state, what would our obligations be?
If you get that notice, you might have what's called a subpoena duces tecum. Actually, it'll say, you are to bring these documents or whatever. And usually I'm talking about subpoenas. A notice of trial is usually when you're a party. The document itself will self-explain what you have to do. If it tells you you have to appear, you have to appear. If it tells you to bring something, bring it. If you don't want to appear, you don't want to bring it, then you're going to have to get your legal counsel involved. But just to be clear, that notice, does it tell you anything other than a trial is happening?
No, it's just a notice of hearing.
I would make some calls, wherever that came from, and ask, because it may be that they're just letting you know, which it sounds like, but they may want you to be there, which is a whole nother thing.
Thank
Okay.
you. And thank you, Emily. So I've got a couple more questions here, and welcome the ongoing chat that's been going in there. So we're in the last 15 minutes of our meeting for today. So if you have questions, try and get them in there. So Quentin and Eric and Johnny, if you think about the criminal justice response as an assembly line, first responders are at the beginning of that assembly line. And one of the things that I've learned from the more of the mechanical industry is that everybody on the assembly line knows what they're doing, but they don't necessarily know what the end product is. So if I'm at the beginning of a car, I'm in Michigan, so the car company, if I just am at the beginning and I'm working around maybe molten steel or something like that, back when cars were made with steel, I don't necessarily have a perspective of the pride that goes into the end product. I don't see it coming off the line. I've always thought that one of the things that we could do in our work in the domestic violence movement would be for all parts of the system to spend time with other parts of the system. So specifically, my question is, what would you think about law enforcement coming to visit a battering intervention group as a way to see, okay, I made the arrest here like 6 months ago. I have no idea what happens throughout the rest of the case. Maybe I'm involved in the criminal hearing. Maybe I've heard some reports because I talked to the probation agent, but I'd like to see what it's like a little further down the stream. What do you think about that?
Again,
I've actually had the opportunity to do that. I've been to batterer intervention program meetings for men and women, and it was an eye-opening experience for me. And it was it took a little bit for everyone to feel comfortable with me being there, but I think it's a great idea if you can get into that and see how those things work.
I think it's the one-on-one syndrome again. If you're making widgets, you're making widgets. The widgets go into something else. If you're handling domestic violence calls, you want to do that as good as you can at a high level of competency. But if you get into it too deeply and worry about, I did a really good case, now is it going to be prosecuted? You worry about what somebody else is doing in prosecution. I did a really good case. I wonder how the judge is going to rule. You worry about that. I did a really good case. I wonder how the survivor feels about my work. That way lies madness. Do the thing you do as best you can. Our champions, the ones who are exceptional, the ones who are beyond the 101, the ones that we call in the middle of the night and depend on, they're already curious and they're going to find out all they can. But your basic guy is what we're looking for. Can you get to the house, take a report, and do a competent job? If that happens across the county and a jurisdiction, what they know about prosecution, judges, therapy, counselors, advocacy, or all the other parts of a very complex system, at some point there may be an epiphany and they want knowledge. Right now, I really want competency.
Mm-hmm. I get that. Johnny, anything you want to add? And you've actually done both, right? You're facilitating groups and you've been on
Yes.
on patrol.
Yes, and one of the things that, you know, for the officers that are out there uh, that are doing the job, that are, you know, you don't have to ask them to stay later and do the report, but are actually getting it done. You know, I am seeing throughout the state, in an earlier question you asked about what do officers need, and I think some of the things that they're needing are more money for the collection of, or the management of a requirement that all officers are facing under Senate Bill 8, that video and that tape. You know, I was talking with Quentin, you know, a while back, you know, in some places, there's a, you know, officer can go in, park his car, and everything's downloaded. Everything, you know, goes into a system. But in a rural area, you know, they don't have those finances to support that. So what's required of an officer in a rural area for a successful prosecution, it's hard to accomplish because the agency doesn't have the money to go ahead and produce that video in a timely manner. And maybe that's, you know, one of the other reasons why, you know, an officer at the very end, you know, he wants to do it, but so many times it's, you know, you hear, well, the officer arrested and the case got dismissed. Well, there's things beyond what an officer does that, you know, factor in on why that case was dismissed. An officer, he doesn't have anything to do in most places with that piece of evidence, that video getting turned over to the defense attorney and to the DA. You know, many places an officer does everything, where, you know, 1 or 2 man department. But, you know, there are those many different agencies throughout the state who aren't afforded, you know, what some agencies take for granted. I mean, collection of evidence. The other thing too is that you can see that some places officers are getting paid $15, $16 an hour, you know, and you give them the training, they get on, and they move on right away. They leave an area and they go to where they're, you know, they're getting more money, and, you know, they're able to, or they come into the agency with a degree as opposed to, you know, not having one. So all these factor in, and I think those are a lot of the discrepancies that we're seeing. But if we all stand on, you know, do your job, get a report done, and hold them accountable that way, I think it's going to strengthen everything that we're doing. But again, too, I think finances play into, you know, the equipment that they have and they need. You know, one place might have a camera. You know, there's agencies where they don't even have a camera. They're taking, you know, they're taking pictures off the phone of evidence and then trying to, you know, move that into the chain of custody. So there's a lot of things, but understanding what's available and what resources are in the community, I think, you know, an officer being able to get and do at a scene that's 50 miles away from his police station, being able to do an emergency order protection in the middle of the night and getting it on his computer and getting it all printed out, getting it executed. I mean, there's a lot of places that can't happen, you know, where you're having, it's just not gonna, it's just, it doesn't exist. You know, they've got to go back, they've got to, you know, so I think too, if we want law enforcement to do a better job, we've got to support law enforcement with the money they need to do a better job.
Well said. 2 last things. One is I'm going to put out the bat signal for, I'm not sure if you are Elisa or Alicia. You'll see in the chat, somebody, if you could use that email address in there and send her your meeting agenda. If you have like a blank agenda of kind of a format for that, please share that. And Alicia, also, later in December, we're having a 3-day coordinated community response training that's kind of bringing this all together. It's going to be a 3-day long one on Zoom, with the training being done at really the epicenter of coordinated community responses from Duluth, Minnesota, of Scott Miller. So I hope you're looking forward to that. I want to end with the question for all 3 of you, Eric, Quentin, and Johnny. about what is the climate for law enforcement officers when it comes to vicarious trauma. That's an issue that we talk about in the survivor movement. We talk about it a little bit in battery and intervention work, but you guys are out there, first responders, doing this work, and domestic violence is gut-wrenching. You know, the stuff that you're having to deal with is gut-wrenching. Do you have the support that you need internally, externally, to take care of yourselves?
I don't think we can get there from here. The problem being, if we say that something is bothering us on a mental level, we skirt fitness for duty. And if we have something that we've seen that is really problematic, you know, there's departments where they can say, okay, we have a employee assistance program. You can go to that. But does that make it to your evaluation? It shouldn't, but it does. If there is something in your mental makeup that requires to be looked at, people are saying, well, does that need to be disclosed to the defense? Is that man ready to carry a gun? Is that something that needs to be involved in his divorce as I sue the department? Are we putting an unstable individual in a position with a weapon? And also the macho part of it is, I'm a man or I'm a woman and I don't need that. I can handle it and I will shed a single tear and move on. We're not ready to actually embrace our mental health in a level that's real. And under COVID, multiply that, exacerbated times 10. You cannot seek help without having the possibility of your continued employment, at least in the back of your mind, being put at risk. And how do we change that? The culture is changing as we have younger, more progressive officers who are seeing the world different than dinosaurs. That's changing, but it's a slow change.
Thank you for your answer to that, and I'm sorry about that. That is really, really rough. There's a lot of thanks that have been coming throughout this to all of you. I want to say Quentin McShane, Eric Thriegeld, and Johnny Trujillo, we all owe you pizza, cookies, and tacos. Thank you. Thank you very much.